Hello, I'm Shelley Grossman, and you're watching Charlie's Dementia Journey. And today we have Michelle Scanlon with us, who's going to talk with us today about legal issues. She is an attorney who specializes in elder law. Thank you so much for joining us today, Michelle.
Thank you, Shelley. Thanks for having me. I'm really happy to be here.
We're happy to have you. Could you share with us a little bit about your expertise?
Yeah, no problem. So I've been practicing for about 7 years, and I specifically practice in the area of elder law and special needs planning. So I focus on wills, powers of attorney, healthcare directives, and estate matters, trying to prepare people for either long-term care needs or Medicaid applications. So, I have the pleasure of working with the elder population and getting them to where they need to be to make sure they have a successful, transition as they age.
Well, you are a wealth of information.
Thank you.
You're the perfect person to ask this question to. Why should everyone have a will?
So, if you don't prepare a will, basically what happens is the state gets to choose where your money goes, essentially. So by preparing a will, you're able to choose where you want your money to go, who you want it to go to, and how it's divided, right? If somebody doesn't have a will, what it happens is basically they pass away and they call it intestate, which means that the laws of intestacy gets to dictate where the money goes. Usually state law would basically look for the next of kin and divvy it up that way. But a lot of times what happens is people either aren't talking to all their family members, or, they may have a good relationship with some and not others. So by preparing a will, you're really able to, one, give it to the people that you want it to go to, and then also in the different shares that you would like it to go to. And then there's also different things you can build within the will. So different tax planning, elder planning. For instance, if somebody's going to be going on to Medicaid, you may not want to leave money outright to your spouse. By doing a will, you can do trust planning within it and potentially protect a lot of different assets that you wouldn't have been able to do if you didn't have a will. So it's a very important document. And a lot of times people think they know what it is. They confuse it with the living will, but it's an extremely important document to sit down and have a discussion with an attorney just to kind of get your basis on what you can do and how you can achieve the goals that you want to.
I think I shared with you that Charlie, who is my former spouse and my best friend, was diagnosed with 2 dementias, and we kind of had to do everything really fast.
Mm-hmm.
That, I believe, is called the crisis planning. Is that correct?
Yeah. So a lot of times what happens is when families wait to plan, I call it crisis planning because you're kind of last minute trying to get everything together. And when you're in a crisis, you're more likely to have things go awry or not go as to plan, or maybe your options are limited. The sooner you think about these things, the better options you'll have for planning, especially when it comes to capacity. So a person has to have capacity to execute a will. And if somebody's diagnosed with dementia, it's not to say they no longer have capacity. It just may be the longer you wait, that capacity can diminish. So we do want to make sure that people don't wait too long, so that they're still able to execute and put into writing what their wishes are.
So the difference between crisis planning and non-crisis planning is the event.
Right. So basically, a lot of times when you look at crisis planning is like somebody comes to me and says, hey, I need Medicaid yesterday. And I'm like, well, okay, there's certain things that you have to do in order to get there. So a lot of times people wait to the very last minute where, mom and dad no longer are able to make their own decisions. And at that point, we're kind of stuck in this rut of what can we do? Are we stuck with what documents they already had, or if they didn't have any at all? And in those two situations, it could be a poorly drafted document, or it could be no document. And then we're looking at something called a guardianship, which is very involved and involves the court, and it could be expensive. So crisis is waiting for like everything to kind of unfold and unravel, where planning, right, is we're thinking ahead and looking at the future and saying, hey, nothing's really too serious right now. I want to get ahead of what could happen and just make sure I have a succession plan in place. I want to make sure that, my kids will have access to my funds to pay for my care, or, different things like that. So that's what I would say is the difference between planning and crisis. We don't want to have to wait until mom or dad takes that fall or gets that diagnosis. Every person, no matter how old they are, right, over the age of 18, should generally start thinking about these types of documents, because they can execute them. And I like to call them living, breathing documents. They can be modified, revoked, changed at any point in time. So as you have life events, you just naturally update them, right? If you have another child, or, you get divorced, or, maybe you get that diagnosis, right? Those are all reasons to revisit what you've already done. So I'd say they're also not a document that you just do one time and then you put it in the closet and you never look at it again. It's something that you really have to relive and relook at. I'd say at least probably every 3 to 5 years. And then if there's like a major life event, so a diagnosis, a marriage, a birth of a child, different things like that, a death in the family. Those are all reasons to plan, right?
It's interesting that you said a death in the family, because that's when I did my will.
Mm-hmm.
After I experienced 2 major deaths in my family, and I knew that I wanted my wishes after I'm not here anymore to be respected.
Exactly.
I put everything in writing for me, so that way the people who are here know what my wishes are, and that my voice is still heard and respected here.
Exactly. Without you doing this, everyone's just kind of going through the steps and the motions of what maybe they think you might do, where if you plan, you can have very detailed documents lining out your instructions, your wishes, where you want certain pieces of personal property to go. I once had a client who had like a collection of different things, and he was able to like itemize who gets what. I also had this one client one time. It was like 2 of their kids had the same initials, and it was like the ongoing thing in their family was which kid actually made that little art piece. And so it was the ongoing joke, who's mom and dad going to leave it to me in the will, right? So there's all different reasons, whether they're small to somebody or big to somebody else, that planning is really important. So, a will can be completely personalized to whatever you need it to do, whether it's leaving property to somebody, or just, making sure that somebody you don't talk to anymore even is not included. There's all different things that can go into the will to make it unique to that person and what their wishes are.
Well, I would love to talk to you about some of the things that are included in a will.
Mm-hmm.
And I know that for myself and for Charlie, we did certain documents that I think are standard. Can we talk about those?
Yeah. So when I do estate planning with people, it's not just your basic will, right? So the will is the one thing that controls all your assets when you're passing. So all, anything that doesn't have a beneficiary designation, right? So retirement accounts are separate, joint accounts are separate, but like anything that it passes according to your will, that's the will. And then there's other documents that go along with it. So updating your beneficiary designations. So making sure your retirement accounts are directed to the people that you want, making sure they're in line with your wishes. People also sometimes will do bank account designations, whether it's payable on death or things like that. And then also there's something called a revocable trust. That's another tool that some people will utilize, generally for people who have property in multiple states, to avoid probate in each state, right? So if somebody has a house in Florida, but they live in New Jersey, we don't want to have to probate the will in New Jersey and Florida. So what we can do is plan with a revocable trust, have the trust own that property, and then it makes things much easier. Another thing that people do is called a power of attorney. This, I think, is actually one of the most important ones. This document allows a person to have somebody step into their shoes, in a sense, right? Be able to pay their bills, get on to their Wells Fargo account or whatever bank they may be banking with, and make sure, that the mortgage is being paid, that the groceries are being able to be bought. In the event, God forbid, there was a car accident, or you do get that diagnosis and your capacity is gone, you want to make sure that there's someone that you trust that's able to access your financials and make decisions on your behalf. They can sign a deed for real estate, really whatever powers you grant them in the power of attorney will allow them to kind of step into your shoes and almost act as if they were you. They have a fiduciary responsibility to act in the best interest of you. So whether that, means paying the mortgage or selling the house or different things, that's what they're able to do. If you don't have a document like that, what happens, right? The bank's not going to let your daughter just access the account because she's your daughter, right? You have to have this document, and it's extremely important. Banks are very specific about it. The forms will vary based on state. So some states like New York have a statutory form and other states don't. So it can be more kind of personalized and different things like that. And then there's a document that's similar to the power of attorney, which governs the financial. And there's one called the healthcare power of attorney, or sometimes you'll hear it called like a healthcare proxy, advanced directive, living will. They're kind of interchangeable depending on what state you're in. But that document allows you to appoint somebody to make healthcare decisions in the event you become incapacitated, and then also allows you to kind of lay out any end of life wishes, whether you want to be resuscitated or nutrition or hydration at the point where you're in an end of life scenario. So those are the core kind of documents. And then something that kind of goes along with it is states have now started to enact these forms. Generally, they're called like a POLST or like a portable medical order. Sometimes it's called. New York has it called the MOLST. These are basically documents that can supplement your advanced directive or living will, and they follow you from facility to facility, or they stay in your permanent health record. And then basically it's signed by a doctor or a nurse practitioner, and it basically puts into writing your specific wishes regarding end of life and different things like that.
So I have a question about that form.
Mm-hmm.
Same as the 5 wishes?
It's so there's a program called the 5 Wishes, which touches base on the advanced directive portion more. But each state, New Jersey specifically, has this green page, right, that goes with you wherever. So it's a little bit different than the 5 Wishes, because I think the 5 Wishes is trying to address your power of attorney, your advanced directive kind of thing, and doesn't need to be signed by a doctor, where these forms that I'm talking about need to be signed by a doctor in order to be effective.
Thank you for that clarification. And I do think that MOST is in North Carolina as well.
Oh, perfect.
Yeah. So I will put links to POLST and MOST in this recording.
Okay, perfect.
Thank you.
I can send you the one I have too for New York and New Jersey, so you can see their website as well.
Fantastic. I would love that. And one thing that I would really like to touch on is there's a lot of stuff that can, make emotions simmer and come up just for the person going through this.
Mm-hmm.
How does it affect the family?
So this goes back to, the planning versus crisis planning. These types of situations in general are already stressful for the family. So if somebody plans ahead, you're almost taking off a lot of the burden because you've designated specific people to those roles and you've kind of set the tone for the future. But if you're in this crisis and nothing's been pre-planned, the family can get like overwhelmed, not know what to do and not know where to turn. And everything that they try to do, they hit a roadblock, right? So if they don't have a power of attorney, they're trying to access mom's bank account to pay the mortgage. Nope, can't do it, right? So they have to stop. They have to figure out the next move. If you have that power of attorney, at least things would be progressing little by little. Same thing with, if God forbid mom or dad takes the fall and goes to the hospital and the kid lives in another state and they're calling the hospital trying to understand what happened to mom or dad, the hospital's not really going to disclose much over the phone because, again, they're not listed as the healthcare proxy. So all these things that are already stressful are even more stressful when somebody doesn't plan. So it just stresses to me the importance of trying to be as organized as possible to make an already difficult situation a little bit easier.
And what happens when somebody doesn't have a friend or family? Because I know that in the support groups that I'm part of for dementia caregivers, there are some people that don't have any people.
Right. So, that's probably the hardest question I get asked a lot of time is, what do you do if you don't have that loved one or family member? There's a lot of nonprofit groups out, depending on which state you're in. I just recently spoke to one in New Jersey where it's a volunteer guardianship program. And basically this group vets different people that serve as volunteer guardians. So if somebody becomes incapacitated and they have no healthcare proxy or power of attorney in a medical situation, the medical providers are going to act in an emergency, but then they're basically going to have to seek the court to see who's going to make that decision. So I advise people to seek professional counsel, whether it be like a local attorney that can maybe connect you to certain resources, whether there's a nonprofit out there or even some paid services. Some people will professionally serve as healthcare proxies or powers of attorney. And then in the event that even that type of planning did not happen, that's when the state will kind of step in and a guardianship matter would have to be pursued.
And how often does something like that happen?
More often, unfortunately, than you would think. There's a lot of people out there that just don't have family members, or maybe they're the last surviving family member. And, it's unfortunate, but I'm seeing more and more organizations come out and try to kind of serve that population.
Well, if you have that resource as well, I would.
Yeah, definitely. I'll send you the link for them.
Okay. And I was just going to ask a question and I forgot what I was going to ask.
No problem.
Medicaid.
Yes.
Medicaid. That comes up a lot in the support groups. So what are the Medicaid requirements? Because I think there's something about you have to spend down all of your money to like $1,900 or something.
So so Medicaid's a federal program, but it's implemented by each state. So each state's going to have slightly different rules than another. In New Jersey, an individual applying for Medicaid has to be spent down to under $2,000. As an attorney, usually what we're doing is we're trying to get them even a little lower than that, just in case there's income or something coming in that they weren't expecting that would push them over the financial kind of eligibility requirements. So to back up for 1 second, Medicaid has not only a financial eligibility requirement, but they also have a health requirement. So somebody needs to have assistance with at least 3 activities of daily life, whether that is like bathing, needs help eating, things such as like personal hygiene, right? Dressing themselves, walking, mobility kind of things. So as long as they qualify for the medical portion, then they can, move forward to the financial. And basically they have to be spent down to under $2,000 if they're an individual, generally, right? This is for New Jersey. And then if they are married in New Jersey, they actually look at not only your individual resources, but the spouse's resources as well. And then each state will have a cap on what they call like the community spouse. So this is the person not applying for Medicaid. They will be able to keep a certain amount as well. Depending on the state. New Jersey, they change it all the time. I think it's 136 or 139. I'm off by the numbers. They adjust it for gross income every year, but so it just depends on what state you're in. But in New Jersey, I'm going to tell you $2,000 or $137,000 is not a lot to work with. So the program looks at it as if you don't have resources, so that's why you need the government to step in and essentially cover your care. I will say the one common misnomer or misunderstanding about Medicaid is that they'll come and take your assets. That's not really how it works. It's basically like you're not eligible until you personally spend down those assets. So a lot of people think, oh, they're going to come and take my money if I apply for Medicaid. Well, it's really, they're not taking your money. They're making you spend it before you can become eligible. And then there's look back periods in New Jersey. They have a 5-year look back. So they will look at anything that you've gifted or spent, generally over $2,000, and kind of flag those purchases and basically look to see if for some reason, you had $100,000 and all of a sudden you're down to $2,000. They want to know where that $100,000 went, because they want to make sure that you just didn't gift away your money to qualify for Medicaid.
Yeah, because that's done a lot, isn't it?
It is, yeah. Unfortunately, a lot of people don't realize that Medicaid has that look back, or, have not sought counsel about applying for Medicaid or doing any type of long-term care planning. So a lot of times when I have a client do the initial consultation, they're like, wait, what? We can't give our kids $10,000 every year or $15,000 or 16, whatever, that rule that the IRS says you can gift without. That's what everyone confuses. And unfortunately, that's not the case with Medicaid. Just you can't be gifting in order to find yourself eligible. They'll assess a penalty.
So do those penalties apply when a caregiver wants to get paid, like a family member?
Yeah, so there's different things that go along with having a caregiver, right? So just in general, I always recommend having some sort of contract or informal agreement that just basically lays out, this is what I'm doing for the person, this is how much I'm getting paid, and these are the kind of general hours that I'm being paid. And then it can kind of explain the story of why a caregiver is getting paid. You have to be careful with child caregivers just to make sure, if they don't have the qualifications of, the certain medical necessities or different trainings, you can't pay yourself the same equivalent, right? You have to do kind of a lower rate, but you just want to make sure that you're documenting everything, even when your kids are picking up your groceries, right? And then they pay themselves back. You want to make sure you have that receipt for ShopRite that says, hey, I picked up mom and dad's groceries. Here's why I wrote a check to myself. Those are all things that can make a Medicaid application so much better for you than someone who's, done 1 million cash ATM withdrawals and has no explanation for why they were taking out $300 every 2 days. An easier, cleaner application is somebody who's very organized and, knows where checks were being written to and why. So it's really recommended that when you choose whoever you're choosing to be a power of attorney, right, that they're someone who understands the basics and also who understands how to keep things streamlined, organized, and has some financial savvy.
Those are some really good takeaways. Yeah, because I know that a lot of people talk about, I'm going to, speak to mom or dad, and I'm going to, get myself paid as their caregiver.
Mm-hmm.
And I know that is a red flag.
Yeah.
That's
yeah.
a red flag.
anytime that you're a power of attorney and you're trying to write yourself checks or different things like that, you really want to paper the file, as I say it. You really want to make sure you're documenting why money is going to you. You have a fiduciary responsibility when you serve in that type of role. And you want to just make sure everything you're doing is in the best interest of whoever you're serving. And in general, one of the things not only just child caregivers I see, but like a lot of people are going, Craigslist is still out there, but like other services where you're going on Facebook and seeing like in the local group for your town that somebody used this caregiver or different things like that. A lot of times what happens is you may use that person for a year and then they move on. And then what happens now when you have this Medicaid application and you can't track them down or anything, we want to make sure we have like some sort of proof that you were paying them for services, not just giving them money. So any type of caregiver, whether you use a family member or somebody that somebody else recommended, or even a company's going to have that agreement, so you're covered there. But it's really when you use those side people that you need to make sure you're taking that extra step. And we're not handing in the agreement out to everyone. It's just something to have in your side pocket in case Medicaid does question certain payments to people.
Yeah, one of the things that stuck in my mind when you were talking is that if you don't have the training, that you need to pay yourself less than.
Mm-hmm.
That I think is a really important thing for people to remember, because that's something that I've heard over and over from various people, that I'm going to pay myself a really high amount, and they need to pay themselves according to
their skill level and what a fair rate would be. And then also, even though the program's implemented statewide, right, each county has different caseworkers and different people reviewing, and all these people are human, right? So they may review things slightly different than somebody else. But if they start to see in like some applications, like, oh, this person say it was $10 an hour, all of a sudden I have some family member doing $100, like, they need to see some sort of consistency in what the going rate is. So like, it's very important that you're not trying to scheme or do anything in that regard, because it's going to hurt you in the long run.
So let me ask you, when you do estate planning, do you put in there planning for memory care, or can you?
So in the documents that we do, especially in the living will, like advanced directive, we do have a portion in there that like addresses like the ability for someone to stay at home as long as possible, the ability to then, if it's necessary, be an assisted living or nursing home or memory care location. So we do grant the power of attorney that power essentially to allow somebody to go into a memory care if needed. So we do kind of address those things in our documents.
So if somebody is listening to this and they feel really, really overwhelmed by all of this information, what are the major takeaways that you want them to hear?
A power of attorney, a living will, healthcare proxy, and a will. Those three things, right, are the three starting points that anyone can do. It's quick. It can be painless. You get the right person. You can even approach the subject with your children. Like a lot of times I'll meet with family in addition to the seniors, because they want to take like a holistic approach to it. So it doesn't hurt to just start the conversation. And a lot of attorneys can actually do a quick turnaround and really get you those basic documents that, once they're done, you won't even have to think about it anymore. It's just a huge weight to come off your shoulders. The biggest takeaway is those three items. I would say number one is the power of attorney, just because your financial world is really a lot, right? it governs everything from being able to, access somebody's bank accounts, sell their property, their digital assets, real estate, making decisions on their behalf. And by signing a power of attorney now, you could potentially avoid a guardianship in the future. So if somebody didn't appoint somebody to act on their behalf and they become incapacitated, the only option that the family is really going to have at that point is to seek a legal guardianship, which is a court proceeding, right? That's spending time, money, things are getting slowed down because you're waiting to get that court approval. And then more often than not, unfortunately, what I see is that, when crisis happens, families don't always get along and siblings may fight over what the best thing is for mom or dad. And by being able to put it into writing now in your will, your power of attorney, choosing those people that you want it to be, right? You're potentially avoiding a lot of frustration, fighting, because one of the most important things about these documents is you get to choose who's serving. So you get to choose who your financial agent is. Maybe one of your kids is a banker, right? And the other one's a nurse. Like, you get to choose who's the better fit in that document. And maybe, your kids are not responsible or they're not mature. So maybe it's a family friend, or, a lot of times I do have clients talk about the fact that, they didn't want to name their children in their healthcare proxy because they wanted to make sure that their end of life wishes were followed. So they named a specific friend that they really had a long discussion about what their end of life wishes were, and knew it wouldn't be as hard for that person to kind of go through those steps. So that, I think, is the biggest takeaway, is getting those documents and then choosing the right people to serve in those roles.
I love that. I love that. I think that's very important information. And I think that, everybody hears about guardianship nowadays. And I know for me, I was very, very nervous about guardianship because of what's in the news with Britney Spears and Peter Max. And I knew that, Charlie had capacity. And we also went to the lawyer with doctor's notes to prove that he had capacity.
Mm-hmm.
So I wanted all of those documents signed by him so he could have his voice and his wishes heard. So that way we can avoid anything like what's going on in the news now.
Right. Planning is basically giving somebody their voice and allowing it to continue on even after their capacity is maybe not there.
Yeah. And even though, the average person doesn't have the money like Peter Max or Britney Spears, even if you have $40,000, $50,000 or $100,000, the guardianship just sucks that money.
It does. It's a court process. So anything that involves the court is a little bit more unpredictable, right? When you send out that you're wanting to petition for somebody to be their guardian, there might be a family member that you never thought would challenge it, but then they challenge it. And now you're going back and forth, arguing over who's the better guardian, and spending all the money between the attorneys. And then every year you're having to do these accountings and different things. So it does eat up time, it eats up money, and it definitely slows down the process.
So the takeaway for me is to allow your loved one to have their voice.
Exactly.
And to get a will and do the will before there's any crisis.
Exactly.
But if someone's watching this right now, chances are they're on this channel because they have someone who has dementia, or they're touched by dementia in some way. And maybe they have the ability right now, before it gets really bad, to get that will done while their loved one still has capacity.
Exactly.
So how would somebody do that? Could they reach out to you, Michelle?
Yeah, they could definitely reach out to me. Our firm is a national member of Meritas too. So even if you're in a state that's other than a state that I'm licensed in, I can help you find either a certified elder law attorney or somebody else that I work with at a different firm in a different state. So I'm more than happy to have people contact and, help them find the services that they need. I also pride myself on being a connector. So if it's even unrelated to the law specifically, if you need some services in your home, like a pull bar for the shower, all those types of things, I have those connections and resources because I want to make sure my clients are served in every area, whether it's the law or not. So, whether it's a home care provider or, somebody putting a ramp in a home, like we make sure we have those types of connections. So I'm happy to help in that regard too.
You're amazing.
Thank you.
I'm so glad I connected with you.
Me too.
So what did I miss? Because I know that I probably missed some things.
I think we touched a little bit on choosing the right people, but that's probably the last thing I would want to drive home again, is we talked about like the importance of the power of attorney and choosing the right people. But so I just want to explain like the different roles that there are. So in the will, there's the personal representative or the executor. So that's the person who's in charge of like marshaling all the assets, getting everything organized, and then basically just distributing those assets based on what your will says. So that somebody should be, responsible, organized. It could be a family member. It could be a professional. It could be a friend. You could have somebody different than your spouse has. You're not required to have the same person, So somebody who's just a little bit understands finances, but then also knows their limits, right? So just because you've appointed somebody as an executor doesn't mean they have to do it all on their own. A lot of times what will happen, I see it more and more every day, is when somebody passes, that the executor whose name will reach out to a law firm and just ask for help, right? I don't know what I'm doing. Can you step in and help me? So just having somebody who knows their limits too is important. And then the other thing we talked about is the power of attorney. So that's somebody who's going to be financially savvy. I've had a million clients tell me, oh, I'm just going to pick my oldest child because they're the oldest. But then they end up telling me, well, my other son's a financial advisor. And so I'm kind of like having that conversation. It's not about hurting feelings or different things like that. It's really taking the time to think about the personalities and different things and who you should choose. And then naming a successor, right? Not only listing one person in the documents, but having a backup. God forbid something happened to that person. Then the document's kind of void at that point, right? What is it going to do for you if there's no one named? So even naming one or two backups, I find to be extremely important.
I think that's great advice. I know that in my own will, I have like two backups.
Yeah. And a lot of times some people will name somebody in the same generation as them. And sometimes it's talking about, well, okay, you guys are around the same age. Let's think of maybe somebody on the next level, like maybe a niece, or if you don't have any children, something like that, just thinking outside of the box. And I've done it before. I'll get on the call with a family member to explain what it means to be a power of attorney or a healthcare proxy, because a lot of times people just, I don't want to do that. But after they understand like what it actually means, some people are more willing to take on that role. And it's always, always important to actually discuss with the person before you name them, because if you name somebody and then they decline, again, what did you do? You created a document that now doesn't work because that person's declined to accept the position. So that's the other key takeaway there.
I didn't think about that part.
Yeah.
But I'm good to go. So, but I didn't think about that. That's a really good point.
Yeah. So just because you name somebody does not mean they have to accept.
So let me ask you, can somebody decline something you leave in the will?
Yeah. So they can disclaim a piece of property. basically when you pass, if you like bequest something to somebody and they say they don't want it, they can disclaim it. And then it would basically, there's a couple of things that you'll fill out and, submit with that. But basically, yeah, they can reject it if they don't want it.
Can a parent reject for a minor?
Not really. I've never had that come across in my practice, but depending on what it is, I don't know that they can fully waive that right. I would have to look into it more, but I've never had that situation happen.
Just curious.
Yeah. I mean, I've had where parents accept on their behalf, but I've never had anyone actually try to disclaim anything.
I don't know why they would want to.
I know. I mean, I could see it if like somebody left a bird, birds live for like 30 million years, right? Maybe they might want to decline that, but money or, different things like that, I can't see why they would want to. But
yeah, I wouldn't want to. Okay. So what else do we need to cover?
Let's see. I can talk a little bit more, in terms of guardianship. Again, the importance of the power of attorney, because when somebody gets a guardianship, you were talking about it with like Britney Spears, right? You're essentially taking away their rights.
Yes.
So it's a very serious process. And in the state of New Jersey, you actually have the laws, the way they're written, is somebody's appointed an attorney for the ward, the person you're seeking guardianship over. And a lot of times you're responsible for not only the fees that you're paying for you to seek the guardianship, but you have to cover those fees for the attorney that's representing the alleged incapacitated person. So, guardianship can be timely, very expensive, there's a lot that goes into it. And more we're seeing things get contested by different siblings and different things like that, where, a power of attorney can really show your kids why you're making that decision and how you made the decision, right? If you're naming one over the other, you can have that conversation with them, why you're still kind of able to, right? If you're just waiting for the worst to happen and you haven't done any planning, that's where, well, no, mom would have want me to do that, or, like having those conversations. Also end of life planning. We didn't really touch on that, but like, I just went through my own personal experience. My father-in-law passed away, and, having to go through the funeral planning and making the decisions regarding a casket or cremation, even that type of planning is extremely important to have that loved one have their voice, right? So a lot of people think, well, I don't need to have a cemetery plot or think about whether I want to be cremated or buried. I'm young, like, have those conversations, and you can prepay too. A lot of times you can go to your local cemetery or, and lock in the price.
I prepaid.
Yeah. So a lot of people forget about that aspect of planning, and it takes so much burden off of the families, because like it's like so backwards. You're trying to grieve, but at the same time, you're like forced to make all these decisions when you're in an experience of like frozenness. So it's hard. And doing that sort of planning really can take a lot of burden and stress off the family when they're grieving.
Absolutely. I prepaid after, like I said, there were 2 deaths that were not done. They didn't take care of.
Yeah. Yes. Yeah.
And I don't want to say any more about it because I don't want backlash.
Yeah, no, I totally.
And I came home after those 2 deaths and I said, I am prepaying. I am putting this in writing. I am putting everything that I want in writing because I don't want my daughter to have to grieve and deal with this. Because that is just way too much.
It's a lot, you know.
Way
and
too much.
and going along with that, the nice thing about the advanced directive, like healthcare proxy, is you can kind of like lay out your wishes so that your daughter or your son doesn't have to make the hard decision of when to draw the line, like how far is too far. Like, you make that decision for them, right? Because, you know, depending on who it is, you might go to the ends of the earth thinking, you know, that there's something you could do when in reality there really isn't. So taking off that pressure, that, you know, decision, and putting it in writing now, that's a large burden to take off somebody as well.
Yeah, I could tell you that when Charlie and I did the paperwork for him, he was so worried about doing it. Like when we were married, he didn't want a will. For years, he didn't want a will. And then finally this happened. And I said, you have to get a will. There's ways about it. You need to get a will. And the lead up to getting the will was so anxiety ridden for him. But after he got it done and had his voice and had it in black and white, there was this calm that came over him.
Yeah.
And he had his end of life, you know, written into it. And he's like, I don't know why I didn't do this so much sooner.
Right. A lot of times it's like the fear of something, and not knowing what it really is, that prevents people from doing the planning. But, you know, I try to make it as simple as possible for people. Like, there's no need to overcomplicate it. Like, it's just it's like what we're doing right now. We're having a conversation, and then we're putting it into a legal format for you so that we can make sure that when you do pass, it happens in a dignified, kind of organized way, and you hold on to that dignity, and it's not chaos and all these different things. So it can be done in the right way. And, you know, it's a scary topic, so it's hard to approach with some people, but it's a necessary topic too.
It really is. And I think that you are a very calming and centered person to talk to.
Thank you.
And I hope that other people feel able to reach out to you, because I know
I'm happy to talk. You know, it's an overwhelming kind of area that I deal with. So it's emotional, it's, you know, scary, but we try to make it as easy as possible for people. And I'm telling you, once you do it, there's a weight off your shoulders.
Yeah. And let me just ask you, I think you and I spoke about, is there a fee for first consultation?
So I don't charge for initial consultations. Every attorney is going to be different. So depending on what state you live in, or, you know, if they're in a large firm, small firm, it's just going to depend. I do a free consultation, just to get information, kind of go from there. And then I generally will send like a written proposal to people so that they know exactly what I'm going to do for them and how much it will cost. Personally, I flat fee things. I find it much easier for people to wrap their head around. And then also I feel like they're more willing to provide me with the information that I need, rather than, oh, I don't want to call you because you're going to charge me every time I talk to you on the phone. But the only difference is guardianships or, you know, court involved processes like estate administration or something like that. Unfortunately, in those situations, we don't really have a choice but to charge hourly at that point, because we just don't know where it's going to go, right? Where if I'm drafting your estate planning documents, I kind of know where everything's going to go and about how long it takes me and different things like that. So again, that's a personal kind of choice. Depending on what attorney you work with, you may have somebody charge differently.
Well, thank you so much. And I hope that you'll send me over your information so I can link it to this segment.
Yes, definitely. I will. Thank you so much for having me. It was such a pleasure. And I hopefully I was helpful to at least one person out there. And, you know, I'm happy to help anyone. Shelley will provide my information and you can reach out.
And thank you everyone for joining on Charlie's Dementia Journey and listening to Michelle Scanlon and myself talk about elder law and estate planning in crisis and during peaceful times. And I wish everyone peace, love, and happiness.